Hi guys, the judgment that will be discussed this week is that of Pankaj Rai versus Secretary, Competition Commission of India and others. The issue before the National Company Law Appellate Tribunal was whether the delay of 730 days, including 693 days spent by the appellant informant in seeking remedy before the High Court in relation to an order passed by the Competition Commission of India in 2017 could be condoned. Let's start off by discussing the facts. Three people, that is Pankaj Rai, Pankaj Gupta, and Lakshmi Reddy, filed informations raising competition concerns against NIIT Limited, that is the opposite party. The three informations that were filed allege contraventions of the provisions Section 3 and 4 of the Act. Section 3 talks about anti-competitive agreements, whereas Section 4 talks about the abuse of dominant power. The informants were aggrieved by the conduct of the opposite party, who according to them were abusing its dominant position via franchise agreements and indulging in anti-competitive practices. The informants claimed to be the franchisees of the opposite party in the city of Hyderabad, engaged in the business of providing computer education and training services. The opposite party was stated to be a well-known brand engaged in the business of computer education, having attained the status of a global leader. The informants alleged that first, while the informants as franchisees of the opposite party were initially granted rights to offer a postgraduate diploma in the banking operations course conducted by the opposite party, it was subsequently revoked even though the course was still being offered by the opposite party at one of its centers in Hyderabad. Second, the opposite party was making forays into territories of the informants, depriving them of their legitimate share of the revenue from that area. Third, the opposite party was offering courses at highly discounted prices by entering into an agreement with Accenture and followed a differential pricing pattern for its customers in metros, which thereby jeopardized the rights for the students and the franchisees, thereby rendering the courses offered by the franchisees uncompetitive. The opposite party indulged in predatory pricing as the prospective customers in the franchisee's territory could register online, thereby ruining the businesses of the franchisees. Fifth, the opposite party has arbitrarily reduced the informant share from 20% to 10% in the inferior courses, amounting to an abuse of dominant position. And finally, the informant also alleged poaching of customers by the opposite party through its online training portal, which are similar to the ones available with the franchisees, thereby appropriating the entire benefits. The informant sought an inquiry into this abuse of dominant position by the opposite party by passing appropriate directions. Upon hearing the matter, the Competition Commission of India was of the opinion that there are a number of other players operating in the relevant market who offer similar courses. Relying on the information in the public domain, the Commission noticed that the opposite party has around 400 centers in the relevant market, whereas its competitors also had a comparable number of centers. Based on this, the Commission came to the conclusion that the opposite party was operating in a competitive environment and faced rivalry from a number of similarly placed players in the field. The Commission noticed that even in the limited geographical market of Hyderabad, it faced competition from large players like Jet King, Appellant, etc. Thus, the Commission concluded that the opposite party was not holding a dominant position in this market. Second, it found no substance in the allegations under Section 3 of the Act, as the opposite party had resorted to the online mode of delivery through its learning portals in order to meet the growing requirements of its consumers. Further, it had been supplying all necessary course material and imparting training to the faculty members of every franchisee without discrimination. Finally, with regard to the differential pricing of courses and the revenue sharing agreement, the Commission was of the opinion that the same is not arbitrary, taking into account the lack of affordability and awareness in non-metros. Thus, the Commission found no prima facie case in contravention of Section 3 and Section 4 of the Act and thereby closed the matter. Aggrieved by this order, an appeal was preferred by one of the informants, Pankaj Rai, before the National Company Law Appellate Tribunal in January 2020. Prior to this appeal before the tribunal, the appellant and the other informants had initially filed a writ petition before the High Court of Telangana against the order passed by the Commission. However, the learned single judge was of the opinion that the same could not be challenged in an appeal before this court, as the Act has provided for an alternate remedy and thereby rejected the writ petitions. Dissatisfied with this as well, the informants appealed before the division bench. However, this was also dismissed. Under Section 53B of the Act, an appeal is to be filed within 60 days from the date of the order. The proviso to Section 53B permits the Appellate Tribunal to entertain an appeal after the expiry of 60 days only upon being satisfied that there exists sufficient cause for not filing it within the prescribed period. Now, The question for consideration before the tribunal is whether the appellant has been able to demonstrate sufficient cause which has prevented him from preferring an appeal before the tribunal within the period of 60 days. The arguments advanced by the appellants are twofold. First, the appellant contended that the period of 693 days consumed in litigation before the High Court be excluded as the impugned order was obtained by fraud. The appellant, relying on the judgment of A.V. Papaya Shastri and others versus the government of Andhra Pradesh and others, laid stress on the proposition that writ jurisdiction can be invoked even when alternate remedy is available if there was a denial of natural justice. Second, placing reliance on the judgment in the case of Swiss Ribbons Private Limited versus Union of India, the appellants contended that the appellate tribunal is not an efficacious remedy for a common man of modest means, considering the opposite party had deep pockets. The appellant went a step forward and submitted that the reason for approaching the tribunal was only to seek justice when repeated attempts at the High Court had failed to impress the court to adjudicate upon the matter, even though the appellant had a strong case on merits. Based on this, the tribunal came to the following conclusions. First, the tribunal observed that the observations of the Supreme Court in the case of Swiss Ribbons Private Limited versus Union of India were in the context of establishing a circuit bench of this appellate tribunal in order to ensure that the doors of justice are made accessible to all those seeking it. The tribunal then held that when a statutory remedy in the form of an appeal is available, the aggrieved person cannot be permitted to bypass the said remedy and invoke the writ jurisdiction of the High Court. If the same was allowed, it would provide leverage to unscrupulous litigants to go forum shopping. Second, the tribunal observed that the statute provides for expeditious disposal of cases and also prescribed a period of limitation to prefer appeals against orders, which may be extended if the tribunal is satisfied that there was a sufficient cause to do so. Further, under Section 53B, subsection 5 of the Act, it is provided that the tribunal shall deal with the appeal as expeditiously as possible and make an endeavour to dispose it off within 6 months. Given the objective to be achieved by this special statute and the mechanism provided for speedy disposal of the matters dealing with competition concerns or anti-competitive practices, there can be no hesitation in holding that the Limitation Act 1963 was never intended to apply to matters covered under the Act for which special limitation is prescribed. This was supported by the observation of the tribunal in the case of Geeta Kapoor versus Competition Commission of India and others, wherein it was stated that the purpose of prescribing a different period of limitation under the Act would be frustrated if the ratio of judgments involving the interpretation of the term sufficient cause appearing in Section 5 of the Limitation Act 1963 is applied for interpreting the proviso to Section 53B subsection 2 of the Act. Finally, upon consideration of the ground projected by the appellant, which was linked with merits of the case, found that there was no sufficient cause for not filing the appeal within the prescribed period of 60 days. The appellant's stubborn attitude in pursuing remedy before the constitutional courts instead of filing an appeal before the tribunal can hardly be considered a sufficient cause, and the matter was thereby dismissed.